Now calling case 2500876, the people of the state of Michigan versus Tamila Peterson. People.
Oh, sorry. I'm sorry, Judge. I think you for a second. Good afternoon, Your Honor. Assistant Attorney General Chris Kessel for the people.
Thank you. Mr. Gleason.
Thank you, Your Honor. Gerald Gleason on behalf of Mr. Peterson, who's appearing by video from the Oakland County Jail, and we do consent to the Zoom process. Thank you.
Thank you. Ma'am, please state your full name for the record.
Tamila Oxford Peterson.
Any change in your mailing address?
No, ma'am.
Are you consenting to appear remotely today for your probable cause conference from the Oakland County Jail using Zoom?
Yes.
All right, today is a date and time set for the probable cause conference. In this case, I do want to make the parties aware we did receive a last-minute requested notice for film and electronic media coverage that you were not provided notice of. This was for Fox 2 News. I have this here. This is the notice because we just received it a few moments ago. Otherwise, I think you've received all of those that we have received as well. So, Mr. Gleason, I did have an opportunity to review what was provided to the court, requesting consideration for a stipulated protective order, and I believe we have all signatures. Have you had an opportunity to discuss this case with your client as it relates to her right to a preliminary exam?
Yes, Your Honor, I have.
We've set a date for an exam in this case to ensure that we have something available that would be within the guidelines that she is entitled to have the exam begin within. That's set next week, the 26th of March in the morning. I'm not sure if we're intending to begin the examination on that date. I was curious, there may be some additional time needed based on the protective order, but I'll let you place on the record how your client wants to proceed.
Yes, Your Honor, thank you. I have discussed with Ms. Peterson her right to have a preliminary examination within 21 days of her arraignment, and we're asking the court to accept a waiver of that 21-day requirement and allow us to adjourn the preliminary examination date or set another probable cause conference. The purpose of that request is the amount of materials that the Attorney General and the Detroit Police Department have given us so far, and I expect, based on conversation with Mr. Kessel, that there will be additional information, and we'd like the opportunity to digest that prior to beginning a preliminary examination.
All right. Ms. Peterson, did you have an opportunity to speak with your attorney about your right to have your preliminary examination begin within 5 to 7 days of your arraignment date? I'm sorry, we didn't hear you clearly in the courtroom. Could you say that again?
Yeah.
All right, we have an exam date that is scheduled to begin next week on the 26th in the morning, so that you can have your exam begin within that time frame. Based on what your attorney has placed on the record, it appears that there may be a benefit to you if you have some additional time to review discovery with your attorney before we proceed to exam. I'm willing to look at a different date to begin the exam, but that's with your permission, ma'am. You would have to give up your right to have the exam begin within 5 to 7 days of your arraignment. Are you waiving that right today? All right. The only bad thing about Zoom is sometimes the connection is not as favorable as we're hoping, but I believe Ms. Peterson just indicated yes. Could you say that again?
Yeah.
All right, thank you. I will accept the waiver. Obviously, we have other co-defendants that are scheduled today for their probable cause conferences. I have them all lined up here. I didn't bring everyone in. I wanted to handle case by case. But I would imagine if there's going to be a request to proceed to an examination on any or all of these cases, we would want to look at setting it on the same date, and that's going to require everybody to be involved with their schedule. So unless there's an objection, I'd like to set another probable cause conference date, or we can pick an exam date offline depending on how the other cases proceed today. What would you prefer?
You're going to ask that we set another probable cause conference date today, and then I can certainly remain in the court's waiting area if you'd like to bring me in at the end, and perhaps all of the lawyers could confer with the court. I recognize, I believe that the defendants are charged separately by the Attorney General and that there are separate cases. What I'm hearing is perhaps the court is going to consolidate some or all of those for efficiency purposes, but I would want to make sure that it's my position that she's charged individually right now and is entitled to her own trial, absent a motion from the Attorney General. But if the court is going to consolidate, then I can wait around to assist in scheduling if the court would prefer me to do so.
All right, but I'm hearing you say at least for the time being, you would not be opposed to setting another probable cause conference.
That's a true statement, Your Honor.
Okay. Mr. Kessel, anything that you would like to add to the record here as we're discussing how to proceed?
Judge, I think your inclination is correct. I think it's probably best that we have everybody here at once. And I do agree with Mr. Gleason. I think there's a considerable amount of discovery to go through. So I think probably one more, hopefully just one more PCC would probably be the right one.
Okay. And I am going to sign the stipulated order that was submitted to the court regarding discovery, now noting that we have signatures from both attorneys in this case, so that can be processed today. Is there anything else that needs to be addressed on this particular case? I'm sure Ms. Peterson would like to know when her next court date is. I'm just hesitant to pick that PCC date and place it on the record right at this moment in time, but I intend to set it before we conclude with the cases that are scheduled this afternoon.
Your Honor, I don't know if the court would be inclined to address bond at this time, or would it prefer that I issue a file a written motion seeking a modification of the bond? I'm prepared to proceed in either way. Obviously, the magistrate set a bond that, as you can see, Ms. Peterson and her family is unable to meet.
My preference in this particular case, really in most cases, but I think this one as well, is that you file something in writing. I can address it very quickly, but I would like you to articulate your position in writing and then at least give the Attorney General an opportunity to review the position that you're taking and respond. Depending on how quickly you can submit something to the court, I'm able to set time aside fairly quickly to hear it, but my preference would be that you outline anything you'd like the court to consider and the people at least have an opportunity to review it, if not responding to the motion before we actually hear it. So that's how I'd like to proceed with this case, as well as the rest of them today if the issue comes up.
That's understood, Your Honor. We will do that expedition.
Okay. Anything else?
No, Your Honor. Would the court wish me to remain in the waiting room or around, if you will, to discuss dates later on today?
I think that might be easiest. If you don't mind, we'll just put you back in the waiting room. I will allow Ms. Peterson to leave the hearing at this time, and then I know you'll be circling back with her to follow up regarding discovery, a date for a motion regarding bond if the court receives that, and then also to confirm with her the date that we'll be scheduling for the probable cause conference.
Yes, sure. One thing escaped me, and I apologize. The Oakland County Jail does require an order if paralegals are going to enter the jail with discovery from Ms. Peterson to review, and or with a laptop, because I think most of this stuff is going to have to be reviewed on a laptop. Would the court have any objection if Mr. Kessel, who I assume can stipulate, would submit an order to that effect, directing the Oakland County Sheriff to allow either me and or my paralegal to bring a laptop in to review the discovery with Ms. Peterson?
Mr. Kessel, would you want an opportunity to review a proposed order to see if there's a stipulation? I have no issue signing an order. I would prefer if the language is agreed upon, but I think it's probably good sense that you have that prepared ahead of time before you make the trip up there to meet with your client. I'll wait to see if you submit something that's stipulated. If not, we can always address it if you're filing a motion regarding the bond, and I can make a decision, but that seems like something the two of you would be able to work out.
Mr. Kessel and I get along pretty well, Your Honor. I think we can work it out.
All right. So we will note that those are some things that I expect to be seeing here shortly on this case. Ms. Peterson, I know your attorney will follow up with you to provide additional information after we conclude the hearings today. Do you have any other questions at this time?
No.
All right, your bond is continued. That concludes the hearing. All right, and we will put you back in the waiting room, Mr. Gleason.
Thank you, Your Honor.
Good afternoon. 25000878. This is the people of the state of Michigan versus Jeffrey Allen Mosteller.
Good afternoon again, Your Honor. Assistant Attorney General Chris Kessel for the people.
Good afternoon, Your Honor. Alona Sharon on behalf of Mr. Mosteller, who is present via Zoom video conferencing without objection, Your Honor.
Thank you, sir. Could you state your full name for the record?
Jeffrey Allen Mosteller.
Thank you. Any changes to your address, your mailing address?
No, ma'am.
And are you consenting to participate in your probable cause conference via Zoom from the Oakland County Jail today?
Yes, ma'am.
Thank you. Today's the date and time set for a probable cause conference. Ms. Sharon, I'm assuming you've had an opportunity to talk to your client about his right to a preliminary examination in this case and the time frames in which he's entitled for it to begin. How is he going to proceed today?
Yes, Your Honor, thank you. Mr. Mosteller and I did have an opportunity to discuss this. We fully expect to hold an exam, Your Honor. As I'm sure Your Honor is probably already aware, there is a really overwhelming amount of discovery in this case. And as I've explained to Mr. Mosteller, I am still waiting for complete discovery. I had a 2 terabyte drive delivered to the Troy PD this morning, and I know that the detective is actively working on loading the remaining materials onto that drive, and then we're going to make arrangements for me to get the drive back from her. So I have explained to Ms. Mosteller that he has a right to a preliminary exam within 21 days of his arraignment, but that obviously with the court's permission, I'd be asking to push that date out because there's just a tremendous amount of information that needs to be reviewed.
All right. I do want to make a record here. I did it in the first case that was called, but not with this one, and I want to make sure that I have it on record with each case. We did receive a request that came in close in time to the beginning of the proceedings today from Fox 2 News for them to film in the courtroom. It was signed off on. They are here, but I don't believe we had the ability to give you prior notice, so I just want to make sure that that's part of the record in this case.
Thank you, Your Honor.
Is your client prepared to answer my questions about his right to have the exam take place within 5 to 7 days from his arraignment date? Or his probable cause conference, I should say?
Yes, Your Honor, we did review that, and he is prepared. I've explained to him that today he would be waiving his right to have the preliminary exam within 21 days of arraignment, but that he absolutely will have his preliminary exam. It just will be at a later date. If you would like to voir dire him, that's no problem, or I can voir dire him.
Certainly. I'll just ask him a few questions to confirm everything on the record. Sir, have you been able to hear and understand what we're discussing on the record today about your right to a preliminary examination in this case?
Yes, ma'am.
All right. And then most importantly, right now we're discussing the right that you have where you could demand that the exam begins within a shortened time frame from your arraignment date. We currently have the examination date set to begin next Wednesday. I believe that's the 26th of March. We set that date in advance to ensure that if you demanded that the exam begin within that time frame, we could in fact begin the exam. Your attorney has placed a few reasons on the record why it may be beneficial to you to begin an exam outside of that time frame so that she has an opportunity to fully review any discovery in this case and discuss the case with you. But you have the right to demand that the exam begin within that time frame unless you tell me today on the record, sir, that you're waiving that right. Is it true that you're going to waive your right to have the exam begin within that shortened time frame after your arraignment?
That is true. I would like to be as prepared as possible.
Okay. Thank you. I will accept the waiver, and she's 100% accurate. You're not giving up any of your rights related to actually having the exam, just the time frame in which it would begin. So I've accepted that waiver. Ms. Sharon, we did previously have one of the cases called, and there was a discussion about setting this matter for a second PCC versus setting it for an exam date. I think obviously there are a few things that would still have to be determined about how we would proceed with the exam and the defendants here that are all following on the same time frame that we have based on the fact that they were arraigned on the same date. So there are still some things to be decided, and there was a request for another PCC on another case.
Oh, sorry, I didn't mean to interrupt you. Yeah, I think that makes perfect sense, Your Honor.
Okay. We were actually just going to coordinate the PCC date when we were done, based on who was going in which direction. And I know that Mr. Gleason was going to remain available to determine a date that would work for a probable cause conference. I'm assuming you might be available as well once we conclude the
Yes.
PCCs that are set and we could pick a date.
Sure. Do you want me to zoom back in or just hang out in the waiting room?
We are just inviting people to hang out in the waiting room, and if you need to go somewhere,
Okay.
you can pop back in. Is there anything else we need to place on the record? I received also, in this case, a stipulated protective order regarding discovery. It appears to be endorsed by both parties here after their thorough review. I am inclined to sign it unless there's anything else that needs to be placed on the record.
Nothing in relation to the protective order, Your Honor. I did approve that last week, I think. Your Honor, I would respectfully request an opportunity to address Mr. Mosteller's bond.
And I would like to consider any request that you are going to make, but my preference is that you file a motion so that the Attorney General's office has an opportunity to review any argument that you're making regarding bond, and I'm happy to schedule that very quickly once you file something with the court.
Your Honor, if I may, and of course I will do whatever the court wants, but I think anything that I'm going to argue, Mr. Kessel is already very much aware of. And according to the court rule and the statute, the probable cause conference is an appropriate time for the court to conduct a de novo review of the prior bond decision. If, as I said, I watched the arraignment. I obviously was not the attorney at arraignment. I watched those proceedings from beginning to end. I don't think anything I'm going to say is going to surprise Mr. Kessel. Perhaps the court would allow me to make argument, and then if Mr. Kessel feels that he's not prepared to respond, I'd be happy to file a motion. But as I said, I will proceed as the court requires.
Well, I've already made a determination on another case that we called first that was what the court was requiring. And if you get it into the court quickly, I will schedule it next week and hear it. And if Mr. Kessel wants to respond in writing, he can. If he wants to respond on the record, he could do that. If he chooses not to respond at all, that would be his choice. But I would just much prefer that I handle this in the same manner that I'm handling the other case that made a request for bond consideration and asked the court how to direct that request to the court. That was what I advised on that case, so I think it would be appropriate to handle this case in the same way.
Absolutely, Your Honor. I'll get it filed within the next 24 hours. And then would I just get a hearing date from Ms. Eversole?
Yes, I will look to see if there's a motion that's going to be filed, and if we need to, I guess, coordinate with Mr. Kessel, whom would likely appear on all of those motions. We'll do that, but we will make it happen very quickly. I anticipate you'll get it to the court within a day.
Yes.
All right, anything else that needs to be placed on the record on this case?
No, Your Honor. I will, I'll just wait in the waiting room to be called back in for scheduling purposes.
All right, thank you. That's it. Mr. Mosteller, have you heard everything that we've discussed on the record, and you've got a fair understanding of how we're proceeding?
Yes, ma'am.
All right, very well. Then this concludes your probable cause conference today. We will see you at the next court date, whether that's a motion date or a probable cause conference. Your attorney will have that information by the end of the day, I'm assuming.
Okay.
Thank you. Have a nice day.
Thank you.
Thank you, Your Honor.
If I could just have Mr. Markin unmute himself. Thank you. 2500875. This is the people of the state of Michigan versus Gary Markin.
Thank you. Good afternoon again, Your Honor. Assistant Attorney General Chris Kessel for the people.
Good afternoon, Your Honor. Todd Flood on behalf of Mr. Markin, who is on the screen to my left. Maybe you're right.
Thank you, Mr. Markin. Could you state your name for the record?
Gary Markin.
And sir, can you confirm that your mailing address is still in Moscow?
Yes.
Thank you. And do you also consent to appearing remotely today using Zoom for your probable cause conference?
Yes.
Thank you. Today is the date and time set for that conference. Mr. Flood, I know that you recently substituted in for the attorney of record at the arraignment. The court signed off on that, so you are now in the system here as the attorney of record. I'm assuming you've had a chance to talk to your client about his right to a preliminary examination. How is he going to proceed as it relates to that right?
We're going to hold a preliminary exam, Your Honor. We understand that because of the volume of evidence and material, it's going to have to extend past the 21 days.
Okay.
But we are going to hold the exam.
Did you talk to Mr. Markin about his right to demand that the exam takes place within 21 days of his arraignment date?
I have, Your Honor, at length, and he understands that he has the right to have that within that time frame, and he's going to waive that right. Mr. Markin, you understood that we spoke about that last night?
Yes, I do.
And you understand that you have the right to have this within 21 days, and you're going to waive that right to hold the exam at a later date?
Yes, I do.
All right, so Mr. Markin, just to expand on that a little bit, we do have an exam date that was already scheduled right at the time that you were arraigned. We found a place for a possible examination to begin on the court's docket Wednesday, March 26th, and we set the exam for that date to ensure that if you wanted to begin the hearing within that shortened time frame, you would be able to. If at this time I accept your waiver, as your attorneys outlined, that means you will not be proceeding to a preliminary examination next week on Wednesday, but at some point after we get some additional information from your attorney on your behalf, we will be setting a date for a preliminary examination. Do you understand that?
Yes.
And is that how you wish to proceed today?
Yes, please.
Okay. I also received a stipulated protective order in this case regarding discovery. Unless there's something else that needs to be added to the record, it seemed appropriate and the court intends to sign it, and will produce copies for both attorneys in this case. Was there anything else that needed to be addressed as it relates to that order?
Nothing from the defendant, Your Honor.
And I'm sorry, Mr. Kessel, I think you were talking at the same time. Could you just indicate if there was anything else you had to add?
Absolutely, nothing for the people, Judge.
All right, and then just as a practical matter, we did receive a request and notice for electronic and film media coverage that came in close in time to when we started the proceedings today. This was from Fox 2 News. We did not have an opportunity to provide notice to the parties in our normal course of business here, so I wanted to make sure that there was a record that I was advising the parties of this today on the record. What else, if anything, do we need to address on this matter?
Your Honor, just bond, if I may, briefly.
Okay, so I have taken a position at this point that if there are going to be motions made regarding bond, I would prefer to have them in writing so that the people have an opportunity to respond. Clearly, I can see that Mr. Markin has posted whatever bond was issued by the magistrate at the time of the arraignment. I'm assuming it's something that has to do with the conditions, unless yourself and the Attorney General are really on the same page. I might prefer that it's in writing. What was the request?
I think we're on the same page from the extent that, Your Honor, that the government is going to leave this within your discretion. I'm just asking for, my client's on a tether, and he has counseling, therapy, church, and the travels throughout the day. Right now, he's strictly to home confinement. I'm asking for a little leeway as it relates to him being able to stay within a certain radius of his home and be allowed to travel, especially to the extent of going to church and the like.
Okay, well, I know that there is another motion that's still left to be determined on a case with a co-defendant that had a tether condition imposed with some restrictions. It was my understanding, at least in that case, as I had reviewed it because I did receive a motion, that the tether was put in place, but there was an ability to have Mr. Markin leave home for purposes of meeting with his attorney, any medical appointments, any court appearances, or any verified employment. Is that your understanding of what the current condition is?
That's correct, Your Honor.
Okay. So obviously, although it is listed here as home confinement, it does permit a number of reasons that Mr. Markin has the ability to leave the house. I think there's an added requirement here that instead of just leaving and indicating that it's for these purposes, they have to be verified. So there is that additional level of verification that would be needed of pretrial services. The report that they prepared in anticipation of today's date indicates that they've met with him, they've gone over all of the rules and regulations, that there was a clear understanding put forth by Mr. Markin that he understood them, and he understood any and all exclusion zones that he would have to comply with. I don't know that I am hearing anything at this point that would be substantial enough to make a change at this moment in time. Is there a position that the people are formally taking on this request?
Judge, I have spoken with Mr. Flood, and if we'll leave it to the court's discretion to the extent that some of the travel restrictions as far as places can be eased up. We would leave that in the court's discretion. I do agree with counsel's suggestion that maybe there's a radius of how far away from his home he could go. I think that would be appropriate, but I do agree with Mr. Flood, generally speaking. We will leave it in the court's discretion as far as tether conditions.
I know he agrees with you much more on other things, Judge, but as it relates to the tether, we're in agreement with that as well. I just to the simple extent, Your Honor, you know, and I know you don't know my client from Adam, lifelong resident, big family, daughter's getting married relatively soon. There's no issues of flight. There's never, as you well know, this case is has other issues as it relates to this. I think, candidly, if the court wants, I can put in writing a request, if that's, and we can address it another time, but just the ability to go to his therapist with that and church and, you know, to stay within the confines of where, you know, a certain radius around, you know, to and from a store, to get eggs, to do whatever, those types of things. But I have no problem if the court desires for me to put this in writing for you. So
I just think that it would be preferable, right? Because you've, I think, made a very good point. I don't know your client. I don't know anything about him. I don't know anything about his schedule. I've put in place requirements with the two previous defendants that were up for PCCs today to file motions. I think their circumstances may be a little bit different because they may be seeking the court to consider the actual cash amount that was set for bond as opposed to your client who's posted a bond and is released now. But I get a little bit concerned about trying to decide here, just on the record, based on representations, what may be appropriate for him to go or not go. It may not even be required, but I'm assuming that this condition was put in place to ensure that he remains in the state of Michigan, perhaps that there's a way to ensure that there's no contact with any of the named co-defendants, that he doesn't return to certain locations. I think we can hash all of this out, but I don't want to do it without additional information. And I feel like we would just be picking something that seems fair without an opportunity to really explore anything, because having a certain radius from his home is not necessarily going to serve the interest that perhaps the magistrate was seeking to serve at the time. And I'm not certain that I'm inclined to make changes, but I think if you have an opportunity to articulate what it is specifically that you're asking the court to consider and the reasons for it because of Mr. Markin, I'll consider it. And the people may take the same position, which is that they're leaving it to the discretion of the court. But I feel like having any sort of discussion about this would just be a little bit arbitrary based on the lack of information that I have about your client and the fact that I know he's at least had an opportunity to have certain things carved out for him to participate based on the magistrate's order. So there is some flexibility there. If you think that something beyond that should be considered, I would prefer that you just file it here at the court and we can set a date and I'll have a better opportunity to review it.
Not a problem, Judge. We'll have it done relatively soon, either by the end of today or tomorrow.
All right, that sounds fair. Anything else that we need to address on the record?
No?
Not from the people, Judge, thank you.
All right,
Not
Mr.
from the defense.
Thank you. Mr. Markin, everything remains exactly as it was originally ordered as far as bond. Right now, I do not expect to see you here on the 26th for a preliminary examination. We will, after we're done on the record today, confirm with the attorneys here to select a date. At this point, it sounds like at least 3 attorneys will weigh in, and they may seek to have a probable cause conference that's been adjourned from today's date on the same date. But we will figure out the logistics of that scheduling, and your attorney will let you know when you will next need to appear at the court. If there's a motion that's filed regarding bond, you will get notice of the date and time to appear for that motion and how I would ask for you to appear. Do you have any questions?
No, I don't. Thank you very much.
All right, thank you, sir. Have a nice day. And Mr. Flood, if you can just stick around in the waiting room, we'll get back with you here shortly and talk about a date to return.
Awesome. Thank you, Judge.
Thank you. All right, 2500877. This is the people of the state of Michigan versus Alita Moffett.
Thank you. Good afternoon again, Your Honor. Assistant Attorney General Chris Kesselhorn.
Good afternoon, Your Honor. Ellen Michaels on behalf of Alita Moffett. My P number is 67943. Ms. Moffett is present over Zoom. We agree to proceed over Zoom with all of its restrictions.
All right. Thank you, Ms. Moffett. Could you state your full name for the record?
Alita Harward Moffett.
And are you still using the same mailing address that the court has on record here?
Yes.
Today is a date and time that's been scheduled for a probable cause conference for Ms. Moffett. Have you had an opportunity to speak with her, Ms. Michaels, about her right to a preliminary examination in this case?
I have, Your Honor. We are requesting a preliminary exam. We are waiving the 14 to 21 days time requirement for an exam because we do need time to review the voluminous amounts of discovery.
All right. Ms. Moffett, have you had a chance to speak to your attorney about your right to have a preliminary examination in this case?
Yes, Your Honor.
Now, the law provides a safeguard to you that the examination, if you seek to have it begin within a very shortened time frame after you are arraigned and after you proceed to a probable cause conference, you can demand that that hearing starts within 21 days of your arraignment date. Do you understand that?
Yes.
Now, we already have an examination date set in this matter. It is scheduled to begin next week on Wednesday, 9 o'clock in the morning, March 26th. We set that date right at the time of your arraignment. We set it at the court to ensure that you could have the hearing begin within that shortened time frame. Your attorney has placed a few reasons on the record why it may be to your benefit to still exercise your right to have the preliminary examination, but not have it begin or take place within that shortened time frame. In order to set another date beyond that time frame here, I need your permission. Are you waiving your right to have your exam begin within 21 days of your arraignment?
Yes, I am.
All right. I will accept that waiver Ms. Michaels, we are looking at the potential of setting another probable cause conference in these cases that are assigned to Mr. Kessel, so that each attorney has the opportunity to review discovery. Each attorney has indicated that it is fairly voluminous. We are likely going to set the second PCC date here when we conclude the hearings today, so that we can see if there are dates that work for everybody that's involved. So I'm not going to place that on the record. I received a stipulated protective order regarding discovery that was signed by both yourself and Mr. Kessel in this case. I'm assuming that both parties are in agreement that this is what they're asking the court to consider, and if so, I'll be signing it today.
We are.
Okay.
Yes, thank you, Judge.
All right. Also, for the record, we did have a request that came in from the media close in time to the beginning of the proceedings starting today. We did not have enough time to send a notice by mail or telephone through the clerk's office like we typically do. So I just want to make sure that there's a record that in addition to the other media requests that were received, Fox 2 News requested to observe film the proceedings today. They are here in the courtroom, so I want both attorneys to be aware of that. There was a motion that was filed by Ms. Michaels. I'm not even sure what time that came in, but it might have been shortly before the court was open. I don't know. I did receive it. Mr. Kessel, I'm not sure when and if you received it. Obviously not enough time to respond. This is another case where there is a request, but a motion has been filed. I don't know if we are seeking to proceed today, or Mr. Kessel, if you want some additional time to respond, and we can set it on a different day.
No, Judge, I did receive Ms. Michaels' motion. I did get it last night. I did have a chance to review it. I note that, and if you'll excuse me, Judge, I'm pretty behind you here. The only amendment that I note that the defendant is seeking is just to remove the home confinement. I'm sure, Judge, that in the previous case, Mr. Markin, I think there are some exceptions to the home confinement that were built in to the order, but to the extent that the defendant is asking to not be on house arrest, essentially, the people would leave that in the court's discretion, although we do believe that staying on a GPS tether is appropriate, but the people have no objection to granting the relief that's requested at this time, or at least leave it that way.
Okay. Well, Ms. Michaels, I want to make sure that we have the same information as to our understanding of what the current condition is. When I reviewed your motion, you indicated here, paragraph 3, that your client is only allowed to leave home for medical and legal appointments that are planned in advance. My review of the court file and the pretrial release order carved out other reasons that she would have permission to leave. Do you have that information?
I do. I have a copy of the pretrial service order that they were kind enough to send to me, and the order that I have and states that my client is to wear a GPS tether, has home confinement, restricted for court, attorney, medical, and employment. And the pretrial service agent I talked to confirmed that. We are asking, based on our motion, for a broader ability, actually removing the home confinement. My client is charged with manslaughter, a 15-year max, while the other defendants are charged with murder in the second degree. So I would like to see her set apart based on the charges. Also, as you see, I have submitted letters that describe the character of my client with a little bit of information in my motion to amend bond conditions as to the allegations of my client's involvement in this case. Based on all those reasons, as well as the position of the government, we believe that home confinement is not necessary in this case. We have no objection at this time for her to wear a GPS tether so it can be monitored where she is. We don't believe her she should be restricted to her home. There's nothing suggesting that in a Class C misdemeanor, she should be on home confinement at this time.
Okay. Well, I think that there's probably some conflicting language here. It is home confinement in that the expectation is that she is at home unless she's at one of the places or locations that are specifically delineated in the pretrial release order. So she's not expected to remain in her home 24 hours a day, 7 days a week. She is given a certain carve-outs here that were identified by the magistrate that I think we're on the same page, and I just wanted to make sure you had the same information because the motion that you filed indicated that she only had permission to leave for medical and legal purposes. I don't know if...
She's not currently employed because her employment was Oxford, so that wouldn't give her the ability to leave. And she's not actively going to school, so that doesn't give her the ability to leave. Also, she needs to give 24 hours notice before she goes anywhere. We're asking that she allowed to take care of her life, grocery shop, see her children, go to her children's home, live her life.
Okay.
The conditions don't allow for that.
So in reviewing what was submitted in support of your motion, there was also some indication from one of the people that submitted a letter on her behalf that she is employed, that she's a part-time real estate agent. So I'm not sure what's happening there, but that seemed to indicate to the court that she did have employment beyond her employment at the facility that she was working at. So I'm not entirely sure where she stands with employment based on this conflicting information. Actually, that was in multiple letters.
She's a part-time real estate agent, and the last time I spoke to her, she wasn't actively working based on the trauma from this incident. So currently she is not. That is something she would go back to when she's able to.
Okay.
And according to the pretrial services, she does need to give advance notice of where she is going and when. As a real estate agent, she would be going to a lot of different locations, and giving that advance notice would also preclude her from doing her job in a way necessary to be successful. But my larger point is, I believe home confinement for this particular client at this time is overly restrictive, and having a GPS tether on will satisfy conditions to keep the community safe and to assure my client's appearance in court.
Okay. Well, at this point, I think I am uncertain as to how much effort has been put in place to at least try to operate within the confines of this particular order. It seems to me as though the things that she may want to do or need to do in terms of treatment or employment, she would have the ability to do under the current order. But I'm not sure if it's just an unwillingness to get the verification ahead of time, or perhaps an uncertainty about what it is that she intends to do going forward here while on bond. But if there is a documentation that you want to provide to the court that there is need for treatment, medical, the ability to seek employment, to work as a real estate agent, I'm happy to consider all of those, but basically the argument right now seems to be one of convenience. And I don't know that I'm inclined to make that change with the limited information that I have. So respectfully, I am going to deny the motion as you presented it here. I think that there may be an ability for you to get additional information so that you can establish that it really would be difficult for her to complete job requirements or participate in treatment or anything else that you listed based on the current conditions, but with what I have here, which is somewhat conflicting, really, after digging into the letters that were submitted, I would prefer to take another look at it if you have additional information that you would like the court to consider. So I'm going to...
There's something that I'm unclear about, so, just so we're clear, so at this time, do the bond conditions allow her to grocery shop, go to the bank, and take care of personal business?
No.
I'm asking for even 2 hours or 1 hour during the day to take care of personal business, and the alternative to what I asked for.
Okay. I don't know that I would be able to just pick a time during the day that she can take care of personal business. I think if this is something where you are seeking the court to expand on the need to be out of the home or participating in certain activities, seeking employment or being employed, I'm happy to consider any information that you would like to provide that would indicate that is what is happening at this point. I feel as though just simply picking a time during each part of the day to allow her to be out freely running errands is not necessarily going to give her the freedom that it appears she's seeking, and it would really just be arbitrary. So at this point, I would like to have you provide any additional information that you have about reasons that she would need to be operating outside of the current restrictions that are in place, and I would be happy to consider them. But based on what I have here in front of me, I'm not going to grant the motion that you're asking the court to grant.
Thank you.
All right. Is there anything else that we need to address on the record on this case?
Not from the people, Judge, thank you.
No, Your Honor.
All right, Ms. Moffett, I know your attorney will be in touch with you to make sure that you are fully apprised of decisions that were made on the record today. The court is also willing to review any bond conditions should your attorney submit additional information to the court, and we will decide a date that you'll return for the probable cause conference here shortly, and your attorney will let you know. We'll also send you notice from the court.
Okay, thank you.
All right, thank you. Have a nice
Thank
day.
you.